Hi, my name is Michale Burgis. I'm a legal certified specialist in California workers' compensation. I'm a trial attorney. I'm the founding partner of MB&A. I wanted to take a few minutes to discuss a common issue in California workers' comp claims, and that is denied medical treatment. In fact, I'm going to tell the viewers a little trick that most people don't know on how to actually get medical treatment approved. Hint, it's going to involve court jurisdiction and being proactive versus reactive. There's a labor code that most attorneys don't know and aren't using, and that is Labor Code 4610B. Now, Labor Code 4610B, what that says is if a treatment request is per se compliant with a respective guideline and that is denied by the insurance carrier, the court does have jurisdiction and can award the medical treatment. What this means, let me break this a step back. In California, if you have an accepted workers' comp claim and a physician wants to perform medical treatment or any treatment, they have to submit what's called an RFA, request for authorization. Now, that request for authorization should delineate what medical treatment that physician is requesting, and it should delineate, quote, why it's reasonably medically necessary to cure and relieve the effects of those industrial injuries. Now, what is, quote, reasonably medically necessary to cure and relieve the effects of the industrial injuries is usually deemed compliance with some respective guidelines. In this case, MTUS, Medical Treatment Utilization Schedule, and sometimes American College of Environmental Medicine. Now, what we can do is we can pull those guidelines and look at exactly what the physician needs to show in order to show that the treatment is reasonably medically necessary and compliant with those guidelines. Now, if the physicians have done that, and that gets submitted to the insurance company, usually to the utilization review department, and it gets denied, the court does have jurisdiction on that. Now, normally, an RFA gets submitted. If it gets denied, then that physician or the injured worker or their attorney can appeal it to something called IMR, Independent Medical Review. But in my personal humble opinion, IMR is very often futile. And really what I want to do is I want to get the court's jurisdiction, because as a trial attorney, that's when justice can get done, when I'm in front of a judge, when a judge can hear my client, hear the pain they're in, and actually order and award that medical treatment. Now, in order to give medical treatment or have the court have jurisdiction, usually there has to be a denial of care or an untimely request for authorization denial, meaning you are denied it more than 5 business days or more than 72 hours if it's an emergency basis. Or if the parties have deferred that to an agreed medical examiner. That case is called the Wiggs case, which was a Judge Devine trial in the Van Nuys Workers' Comp Board. But ultimately is this: we want jurisdiction. And there's a niche that nobody really knows about and isn't using, and that is Labor Code 4610B. So if I can get the court to have jurisdiction, it's still the injured worker's burden to prove that treatment is, quote unquote, reasonably medically necessary, which means generally they have to show it's compliant with those guidelines, right? So why not be proactive versus reactive? That is, if I'm the injured worker's attorney, I talk to their primary treating physician and I explain to that physician, because oftentimes they don't understand what they're supposed to do. Now, I talk to that physician, I explain to them what they need to do, I have them resubmit the RFA, I have them show it's compliant with the respective guidelines verbatim, and I have them re-request that RFA. Now, if that RFA is then later denied, guess what? If it's verbatim consistent and the medical evidence establishes that they've met all the requirements pursuant to that guideline, once again, usually MTUS or ACOM, I file what's called a declaration of readiness, or generally an expedited trial on that basis, and I go down to court and I try the case and I get justice for my clients. So if you're an injured worker and your treatment is being denied, and your physician has been unable to get that overturned, or you're represented by an attorney who's telling you there's nothing they can do, call my office. We can go over an individual analysis of the case and see if we can get the court to have jurisdiction and if we can get that medical treatment awarded. And if you've found that this video has been helpful, please subscribe to my channel, as I have many informative videos that are really designed to just help. Thank you.